first knew of Barbara Hart's work when I attended the National Coalition Against Domestic Violence in 1980 conference in Washington, D.C. And I also attended workshops she had been involved with for the National Coalition Against Domestic Violence. So I was really pleased last night to have dinner with her and several other friends from Oregon and to personally find out about the work. It never ceases to amaze me how social workers can talk over dinner about some of the most crucial problems we have in our society to deal with. Barbara Hart received her master's in social work in 1971 and her law degree in 1975. She has been active in the domestic violence movement throughout her career as a social worker, a consultant, and an attorney. She worked with several programs early on with socially troubled young boys from 65 to 72. And in 1974 and 75, she helped organize and coordinate the Women's Legal Clinic, which provided free legal services to women in the District of Columbia, in addition to developing model rape legislation for the district. In 1975 to 80, she worked as a staff attorney for the Central Pennsylvania Legal Services, specializing in family and labor law. She won the first unemployment compensation case based on sexual harassment in the Commonwealth. Barbara continues law practice as a private practitioner specializing in family law. And since 1980, she has worked as a staff attorney for the Pennsylvania Coalition Against Domestic Violence. And she's responsible for the development and implementation of training for police, courts, parole agents, district justices, court administrators, district attorneys, and battered women advocates on legal issues related to domestic violence. So she works with the 57 battered women's programs in Pennsylvania on legal and political issues, legislative drafting and monitoring, and supervision and development of staff of the police, court, justice agency components of the Pennsylvania Coalition Against Domestic Violence. She's also a writer and has published Battering and Addiction, Consciousness Raising for Battered Women and Advocates, and Confronting Domestic Violence, Effective Police Response. She's responsible for the design and implementation of training of leadership development for women within the women's service movement with the Leadership Institute for Women. From 1987 to the present, she has served on the advisory board of the National Clearinghouse for the Defense of Battered Women, providing technical assistance to battered women attorneys and advocates working to defend battered women who have been charged with crimes as a result of the domestic violence inflicted upon them. She has worked in the area of domestic violence as a consultant with numerous agencies, including the National Council of Juvenile and Family Court Judges, work on the task forces of elder and spouse abuse for the Attorney General of Pennsylvania, and has done a lot of consultation on school policy relating to children of battered women for Pennsylvania's Department of Education. Works on custody and family law litigation and political organizing for the National Association of Women and Family Law in Canada, as well as working with the Senate Judiciary Committee on federal legislation to end violence against women. Many of you in Missoula may have seen the Missoula publication of the Vision 2020 that they want to see Missoula have in the year 2020. And that dreams that were published, the fifth one that was published was Eliminate Child Abuse and Spouse Abuse. Barbara Hart is definitely in the forefront of that meaningful work for ending domestic violence and assisting those of us working in the domestic violence movement, as well as those who have experienced violence in their lives. Please give a warm welcome to Barbara Hart.
Thanks. I appreciate the litany or whatever. A little embarrassing, but probably a very gracious job. Most of you who know me have maybe laid bets about when I'm going to say one qualifying name, so I'm going to say it right away. Lawrence Baldwin is the man who guided me, and so when we were asked to think about the year 2001, actually on International Women's Day, March 8, 2001, I would have left Lawrence Baldwin 30 years ago. So actually the year 2001 has changed me. And I'm sure that in the year 2001, I will continue to do this work and continue to acknowledge Lawrence's role in educating me about the issue. I'm going to talk to you today about a woman named Sarah. She was dead on arrival at the hospital. Her face was so mutilated that she was not identifiable. 3/4 of her scalp had been removed. She had 0 blood volume in her body. The miracle is that she lived. Her survival is testament to her incredible will to live, her inextinguishable desire for justice, and her insistence in her right to be free. It's also a testament to the determined and extraordinary efforts of the hospital and that trauma team that dealt with her when she arrived at the hospital. My concern for Sarah is that she may not, however, be alive in the year 2001. I know that she will do everything in her power to be alive, to stay alive. And we certainly will work with her to help her survival. The truth is that we may not succeed. We will use all the legal tools we now have. We will develop several new ones in order to use these tools to protect her. But we may not succeed. And we will not succeed unless we collectively work, not just in the legal field, but in transforming the entire social context in which Sarah and we all live. Sarah survived to fully participate in the prosecution of her husband and his brother, who had inflicted these heinous assaults on her. They were both convicted after using defenses of provocation. The prosecutor was very meticulous, very thorough. Unfortunately, he failed at sentencing. He forgot that he had to convince the court that the circumstances of his sustained assault were aggravated. And so the court entered a sentence that was right in the middle of the range, not at all at the aggravated end of the range. Which suggests to me that we must be very careful in our legal work to not assume that those who we think are excellent will necessarily do what is required without some reminders from us of the importance of excellent representation from beginning to end. I do want to suggest to you that several things happened in this prosecution which no one believed would succeed. Police did good work. Police had protocol in that jurisdiction. It was one for a preferred arrest. They were great in their investigation. They did excellent picture taking and a whole array of other things that were included in the protocol. They did very good victim and child protection. There was a guard at the hospital for several months. This one was there. They were very excellent advocates for high bail. They imposed no contact orders not only on these 2 men, but on all of their agents, because they were certain that these men and their agents would come after this woman and her children. They provided her protection during all court appearances. They preserved the confidentiality of her secret residence with her children. The cops did great work. This is after the fact. The prosecutor didn't work. I just want to articulate the kinds of things that he did that we don't see most prosecutors doing. There was vertical prosecution in this small Pennsylvania town. That means the same prosecutor handled the case from beginning to end instead of passing it around to a zillion underlings to gather information. And so he was really familiar. Actually, he'd spoken with her many times. I know that in in many courts in my state. The veteran shows up for prosecution and the assistant district attorney is flipping through the chart to try to figure out what happened and has paid no attention to developing the prosecution. This prosecutor had frequent contact with Sarah and her children. He did a good job of preparing her for testimony. Few prosecutors do that. He did excellent referral and outreach to the veterans program to get them involved in giving her support and to help her do safety planning, to help her begin to do healing. Her children were not able to see her for the first 2 weeks because her face was so disfigured that they felt that it would be too traumatic for the kids. Her throat had been slashed and she had been brutally and savagely assaulted by these men. The Veterans Program was able to provide good support to her children, her daughters, and to her mother. And the prosecutor did all of this without a protocol, without any sort of thinking in advance about what should be done to effectively prosecute. Fairly extraordinary, I would say. Since that time, we have developed a prosecution protocol that we are now trying to market throughout Pennsylvania, trying to get prosecutors to buy into many of the things that this fellow did and a few additional pieces. We think that it's critical, and probably the work of the next 5 years across the country will focus on getting prosecutors to develop very clear practices related to prosecution. They're pretty sloppy right now and pretty uninformed. And our hope is that by developing this protocol, and then we've also developed a curriculum around the protocol, we will be able to get prosecutors in Pennsylvania and then hopefully other parts of the country to engage in effective and respectful prosecution. One of the things that is not in this protocol that we developed either for police or for prosecutors is something to do with internal affairs. They've all resisted it, surprisingly enough. And frankly, it probably doesn't belong in a protocol that's for police response or prosecutor response. It may better belong in an internal document related to internal affairs. We've been able to succeed in getting police throughout Pennsylvania to embrace an internal affairs protocol related to police officers who are batterers. And when I was in San Francisco this last week and heard about a batterer within the prosecutor's office who's absolutely unaccountable, it dawned on me that we needed to begin to develop an internal affairs protocol for prosecutors who are batterers. That's just an aside. Anyway, these guys were convicted. They got 7.5 to 15 years. They have been locked up. They've had 2 parole hearings since this conviction some years ago. At the first parole hearing, the prosecutor, who I described as doing really outstanding work, was very concerned that they were going to get released. After all, the parole board had not been particularly clear about violence against women. And so he sent the pictures that the police had taken immediately after the assault on Sarah. The pictures were so graphic that they, in and of themselves, resulted in denial of parole. Few police, few prosecutors preserved evidence, and this is 7 years later that they still have evidence in their files, and often lawyers and veterans programs and everybody sort of, get rid of stuff in their file. This prosecutor had the foresight to know that these pictures might be very significant, and he preserved the evidence, which persuaded the parole board not to admit either of these guys to parole. In Pennsylvania, parole hearings happen routinely once a year. So battered women are often defeated by spending their whole lives because in order to prepare for a parole hearing, you have to spend lots and lots of time. You can never disengage. 7 years later, Sarah has to continue yearly to prepare documents for the parole board to persuade them not to release these guys. The prosecutor in this particular instance, although he did an excellent job at the first parole hearing, decided that he and his office had done enough. That if these guys did 10 years, that was sufficient. It may be, in some other sense, sufficient in terms of justice. It wasn't sufficient in terms of safety. this woman, we believe, is endangered and will be endangered for the lives of both of these men. Anyway, so when the prosecutor dropped the ball after the first parole hearing, Sarah picked it up and called us, asked us for our help. And we, as a consequence, prepared several memos. One on to try to help the parole board understand recidivism. There's not a whole lot of good research there on prediction of more violence or future violence. It's pretty tenuous. And parole boards have been looking for research that helps guide their decision making. So we went into all that literature to see if we could find something that would persuade this parole board. We think that we succeeded. We submitted a memo on behalf of Sarah, on behalf of her 2 adult daughters, and we asked a fellow who's an academic expert to submit another document that clearly described these men based on the record and the chances that they would come and retaliate. What you don't know, what we knew, was that this man acknowledged to his wife, to his third wife, Sarah, that he had killed his first wife. He had attempted to kill his second wife, and she had escaped to Arizona. She was the third wife. He had also, he told her, killed a business associate who had turned on him. So we had a lot more information about this guy than was ever able to be introduced into court, but was certainly able to be introduced to the parole board in terms of talking about a pattern of terrorism and commitment to a homicide as a solution to this guy's problems, and certainly in terms of revenge. The parole board denied parole once again to these 2 guys, and in an unprecedented fashion, they set the next parole date for 3 years instead of 1 year hence. And that means we've got 2 years. Sort of, Sarah had a couple of years, and we had a couple of years to sort of breathe and continue to develop, for she and her children to recover. I mean, it's great, you know. It's a little breath of air, and we wonder why sometimes we prevail. And so I want to encourage those of you. Yesterday, somebody talked about seeding, SEEDING, seeding. And I think it's real important work. Sometimes we don't know it, that we're doing it. But I think that we as a movement can be more meticulous about seeding. And I'm not sure why we won in this particular case, why the parole board decided not to let these guys out. But I have some speculation which I will share with you. I had known the parole board member who I knew had jurisdiction over this case for 15 years. I had a rather interesting relationship with the guy. When I first got to legal services, I sued him. He was the warden of our local prison. And I won. And so for 5 years, I got to see Walter every week. Or he got to really see me every week. And I got to yammer at him about what was wrong with his prison and how we were going to change it, and to really make some efforts to deal with the civil rights issues that we had raised in that lawsuit. We developed a very friendly and quasi-adversarial, but I think fairly respectful relationship over the course of those 5 years. I then left legal services, and shortly thereafter he went to the parole board from this prison. From time to time I sent him a copy of a newsletter of the coalition that seemed to be germane to his work, and sent him other materials, not in a very concerted or thoughtful way, but just, sort of spontaneously it dawned on me, Walter should see this. So, in addition to that, Walter got married again. See, we don't have control of some of these things. He got married into a very wonderful woman who was quite clear about violence against women and the terror that men impose. And so we couldn't have purchased a better trainer. So she sat him for the last 6 years. Then Walter was retiring. I think one of my speculations is that Walter gave a gift to us. We've had a number of instances recently where retiring men give extraordinary gifts to veteran women. The judge in Caller ID, which we worked on, was a retiring judge. He stepped out of his usual conservative mode to say that Caller ID is unconstitutional. I speculate that Walter said that he was tired of violence against women, and this is one thing he could do. He could keep these guys locked up for another 3 years. But who knows if it was wife, it was a retirement gift, it was all of that sort of seeding of Walter over the years. Maybe, actually, our memos were persuasive. I like them, but doesn't mean they were any good. It could be all of those kinds of things. And I think the point of this is that we never know which of those pieces is the most powerful. And therefore, it does suggest to us that we should figure out ways to consistently seed. And it's exhausting. When I get done today, you're going to use the totally exhausted, oh my God, I can do all that work. But somehow seeding in this way is not as exhausting as doing major trainings and policy. And we can do that so it's quite easily and quite naturally. It's something that's sort of in the front of our consciousness about what we should be doing. So I would suggest that maybe you want to start seeding your parole board, however you can do that. I don't know if you have a parole board in the state or if people are admitted to parole, but I think that's maybe something that we should be a little more circumspect about. Something else happened, another outcome related to our advocacy with regard to this parole is that we also became aware of some legislation that was going to eliminate the parole board. We had decided one way to empty out the prisons in our state was to just let everybody out who had completed their minimum sentence, no matter what they had done, to get in there. So no matter how violent they had been, we would let everybody out who had killed people, as well as people who had written bad checks because they were poor, at the same time as their minimum, without any evaluation of their danger to society. And when we learned about this, actually Walter gave me this piece and said, well, I know that you won't like this. And the parole board is in a fairly unusual position in that it's arguing for its own retention rather than elimination. And so I know that you'll do this work. And I said, absolutely, not because you asked, but because it's absolutely fundamentally important that there be some scrutiny of violent offenders before they get out and some conditions imposed upon their parole. And if we go to the system, we are actually just going to let out terrorists without any warning, without any conditions to protect victims. So we had done a good job of stopping this legislation that would have eliminated the parole board. So I think that Walter was willing to give us the gift because he could say to all the rest of his peers, look what great work they did for us. All of this is to say, I mean, this is all principled work. We did not do this in order to gain favor. We did this work because it was necessary for better women and children, that they receive all the legal protections, including the legal protections that can come from parole board scrutiny and imposition of conditions upon release. Let me also say that as a consequence, we have, and I think this is something that you will be doing because the feds are interested in it right now. The federal government has put out 5 or 6 seed grants on victims in corrections. And so the Commissioner of Corrections in my state is one of the 5 or 6 areas that got this grant on victims in corrections. One of the people who sits on this victim and corrections panel is the guy to whom we submitted this paperwork for Sarah. The guy to whom we did the advocacy, not the guy who was the parole board, but the victim advocate within the parole board who saw all of our work and was quite impressed. So that when we show up, we were invited, and by the Commissioner of Corrections to show up. Oh, by the way, on the other side, is I think it's really important for us to fight with integrity. And so when I describe this, the Commissioner of Corrections was the guy that we were fighting with about this parole board. He wanted to let everybody out on their minimum sentence. And so we had to go to this very progressive, we knew he was a very progressive commissioner to say, we don't like your legislation, it stinks. It sucks so bad, you're going to have trouble with us and everybody else, you're not going to get it, sir. And in the middle of this meeting, the legislative aide who was sort of orchestrating this get-together called me a very nasty name. He was a very good friend of mine, and I was appalled, but it sort of equalized all of us in this room. And so Joe got the message that we were going to fight him as hard as we could because his proposal was absolutely representing jeopardy to better women and children. So, 6 months later when he gets his money, he says, okay, girls. He would be very much better than that. He would say women. He wouldn't even say ladies. Okay, women, come sit on my victim and corrections panel. We need to have your input to think about how to do better work with victims in the context of corrections. And so we've been sitting on that, and you will be invited, and if not, you should invite yourselves to sit on that when it comes to Minnesota, because that's the new direction, I think, for corrections right now. And I can imagine for the next 6 years, you're going to be hearing about how do we do a better job with victims related to the correction system. They agreed already that they're going to try to deal with telephone terrorism. I don't know how many of you have people that you work with who are getting terrorized by dads who are locked up. They agreed they're going to begin to prosecute for telephone terrorism those men who are already in prison. So it won't just be that their parole will be denied based on bad conduct, but that in fact they will receive additional sentences for telephone terrorism. They've agreed that they will talk with us and work with us about coerced custodial access. I don't know how many men and women you work with who are required to take their children to prison so that you can have a visit with them, even if the children have nightmares and terrors and have incredible setbacks for weeks before and weeks after. They have agreed to work with us in trying to persuade the courts that this, in fact, is something that is ill-advised. Not in all circumstances. Some kids have very good experience seeing their fathers in prison, so it's not one solution for everything, but we want for those children and those women for whom this visitation, this coerced visitation is untenable, we want to stop it. They've also agreed that, and this is something, there was somebody from Canada here yesterday. Let me just say, if you're still here, that the parole board in Canada is right now considering and probably is going to institute a policy that no matter what an offender gets incarcerated for or convicted of, that as a condition, if there is any history of domestic violence in that perpetrator's background, that a condition on parole will be, several conditions on parole will be related to protecting the victims who he has previously assaulted and terrorized. No matter if he's in there for auto theft or something totally unrelated to domestic violence. So the woman who is deputy, sorry, I don't know Canadian, she's in the cabinet anyway, and who's charged with this, is very committed to trying to look at all of those being released in Canada related to their history of domestic violence and imposing protective conditions to protect women and children. These guys in Pennsylvania have agreed that they will do that as well. They also, even though we don't have a state statute, and it looks like we're going to get we're not going to get passed, they've also agreed that independent of any statutory mandate, that they will develop a system with us to notice battered women of furloughs, escapes, releases, any leaving of that correctional institution, so that victims of domestic violence, actually victims of all violent crimes, will be noticed of departure of the offender from the prison. This is, again, not by statutory mandate. This is something that they have been persuaded would be very helpful. They may be concerned about protecting themselves from liability, but I don't want to suggest that they are, I don't think that they care. This particular group of people really care that the system has not attended well to victims whose assailants and terrorists are in correctional institutions. So by the year 2001, we'll have this in place. And I hope that we have police, prosecutor, judicial, parole board, probation protocols, trainings, systems, and statutes. And we have enough time to do that by the year 2001. Let me suggest there's other work that will be more difficult to achieve by the year 2001. One of them is victim protection plans. We know that the feds run a victim protection plan, a witness protection plan actually, that safeguards those key prosecution witnesses, especially in drug prosecutions that the federal government deems appropriate. Well, we think that they ought to develop, the states, not the feds, to develop a victim protection plan for people like Sarah, so that in fact they can legally change their name, change their social security number, go into hiding, and resume life, with at least the additional cushion of the batterer not knowing where they are and having to look hard. I would impose a few things on Social Security. Anybody who works with Social Security can just go into that computer and look for anybody in the country and get that information to anybody. I mean, it's hellacious, even though we are supposedly protected against the distribution of that information. I would create a computer program, although I'm computer illiterate, but I would have somebody who knows something, create a program that in fact for all those women who are put in the victim protection program, that the regular employees of Social Security can't access, so that women can't be found through Social Security. I think it's incredibly important, not for most battered women, but for the few battered women who are in the position that I think Sarah is, and we have a committed killer who's waiting for access to her once again. And there are numbers of those. And for these women, I think we need to create this kind of plan. It's expensive. I don't want a witness protection plan, however, like the feds do, because it really means that the protected person sits in a house for the rest of their life. I want women who are close to the victim protection plan to be able to resume life someplace else. And I can be, this may be very naive, I'd like to try it and see if it works. I'm a person who has basically been in hiding for the last 20 years. Not in, I didn't change my name, it's Billy Hines. I didn't change my Social Security number, but I had hid Lawrence. Whenever I go back to Ann Arbor, I'm very careful and very circumspect about that. I figured that his commitment to killing me was only if he had easy access to me. He's one of those pretty lazy batterers, you know? So he could find me easily, and he didn't have to move himself too much. He was coming after me. Now, I think that these two guys are very different than that. So that hiding like I have hid has been effective, frankly. I want you to know that I think, Lawrence, there was one time, I didn't figure it out until years later, that this man was intent upon killing me, and I did not recognize it. I just recognized, and I'll say that sort of later, I recognized that he was jeopardizing my relationship with my parents, who were my best allies and protectors, and that I could not risk him doing that, so I left. But on reflection, it dawned on me, it was very clear to me, this man was engaged in an attempt that was so desperate that it meant that in his mind he was considering killing me. So I think there are a variety of ways that women can hide. I just know, and you know, that there are some women who can't hide the way I've been able to hide, who can't just pick up and go, and who don't have the kinds of economic tools to be able to support themselves in this field. Let me go back to Sarah. She didn't seek a protection order. One, she didn't know about them. So one of the things I hope we do between now and 2001 is we do a little public education campaign. We do this a lot around arrest. You know, when we see signs, domestic violence of crime, call your local crowd. We see that in a variety of places. We don't talk about protection orders. And maybe it's because it's real easy. You can't do domestic violence of crime, you know, get yourself a friendly protection order. I mean, it's not so easy to talk about those and who's eligible for them. But I think that, I don't know that it would protect Sarah, but it was an option that she was not able to exercise beforehand because she didn't know that she was eligible. Now, there's been resistance to any public education campaign by you. The numbers of people who will descend on you will be extraordinary. So that if you decide to do that, you need to prepare to do that. The numbers on the courts will get them really irritating at you. We changed the Protection from Abuse Act in Pennsylvania back in 1988. And the only thing that we really did was we gave access to the courts. We permitted women now to come in and represent themselves, to file and prosecute the whole protection order all by themselves. In one county, in the first year, the increase in the caseload went up 700%. The more typical increase, when women finally had access to the court without hardly any advertising, the typical increase was 250%. Can you imagine what would happen if we actually began to talk about the relief that might be available under the Protection from Abuse Act so women would know that this was a legal tool? Instead, we pretty much let women come to us or women come to the court, and we don't notice them. I think that we always have to be strategic when we add new interventions, and that we have to be very careful to make sure there are enough resources for you and the courts if we are going to begin to say to all of those women in this state and across the country, there is a legal tool that may protect you. Use it. Now, had Sarah known about this, however, she might not have been able to get a protection order. And that's because she might not have been able to access legal representation. Because she had at this point not been battered in the way that we typically identify battering that our public education campaign might address. The violence that had been inflicted on her was sexual coercion. She had been denied birth control. He was insistent and terribly, terribly intrusive about his demands for sex. He had insidious jealousy. Basically, she and her daughters and his son waited court on him all the time, and they, were not able to leave their home. So, and under our statute, which includes the element for false imprisonment, they could have obtained relief. The whole family was accommodating this man in ways that they barely could breathe. Without an attorney in my state, you aren't going to get a protection order based on those facts. And with an attorney, you might have difficulty getting a protection order based on those facts. So I think that it's incredibly important that those of us who have developed pro se, and I don't know if you have it in Montana systems, that we now see that very important tool for access to the court as a substitute for legal representation. Because women like Sarah will never be able to get protection without an attorney. Even the best of advocates, I'm convinced in this case, would not have been able to persuade the court or take an appeal if the court was unpersuaded. Judges get very sloppy, as you know, terribly victim-blaming. They don't understand sexual violence at all. There's one very exemplary judge in my county, a woman I've known for years, a good friend, who I just happened to be in court one day, and the woman was on the stand describing how she couldn't swallow anymore and had lost 15 pounds because of her husband thrusting his penis down her throat. That it created such sores in her mouth and her throat that she was not able to eat. She described how he held a gun to his head and said to her, in the presence of the children, that he would kill himself unless she complied with his demands. And the judge said, "These may be indignities, my dear, but they are not abuse." I was appalled. I could not figure out what was happening with this friend of mine, this judge that I thought had excellent integrity. So it was at that point we decided to do a court watch. That our best and most enlightened friends who sit on the bench don't get some things. And they get them much better when we're watching them. And they know that we are watching them. So we began to get women who were volunteers in the community to sit in on every time protection orders were being heard. The hearings, not every time an application was heard. We would just have women in the community, and it was three women voters, and it was the junior league, and it was just all of those women who provided great volunteer support in our community that started court watching and started writing it up. And then, in terms of what Kevin said yesterday, started writing to the newspaper. We have a feature editor. Anybody can write to the feature editor column. Everybody reads the editorials in my community. Everybody reads those stupid little, two-paragraph letters that drive them crazy. So terrible biases, but they all read them, and so do judges. And so we began flooding right after this particular incident. The letters to the editor and guest editorial with some enlightening and not hostile pieces about what constitutes violence against women and how sexual abuse and threats, guns move quickly, are in fact exactly, there are several sections in our statute where this gun to the head would be actionable, is in fact the kind of abuse that the statute recognizes. To help this judge figure that out, we have to do this periodically. There's a doctor who killed his wife by injecting her with some medicine. And the prosecutor and the public defender did plea bargain. 5 years community service, not 1 day in jail. Well, we decided, we had this whole network women volunteers, plus we had the whole bar was pretty incensed by this, or at least they pretended to be. So we all showed up on the day of sentencing, and there was no standing room available. People were outside of the courtroom, which was larger than this room, just no standing room available. And the judge, who might, I think, have otherwise agreed to this plea bargain, denied it when he could not get the doctor to say, I didn't do it. All the doctor would say is, I don't know what happened. And the judge said, because you won't acknowledge that you did anything, I'm not going to accept this plea bargain, I'm going to go to trial. It was a very important thing to have happen. We can have that happen quite simply, actually, as long as we have built the networks to do court watch, to do writing, to help the courts understand that they are under constant scrutiny. Now, we do some other things too. If you have attorneys that work with you or friends, you can also send them, if they're willing to, talk to the judge beforehand about other issues to educate. In fact, 3 days, I guess it was, before Forrest refused to enter this or agreed to this plea bargain, I had gone to talk to him about some concerns I had about issues related to protection order practice. He's the senior president, president judge in my community. I thought there were some local rules that needed to be introduced, and it was I was carefully planned that I went before he had to hear that, so that I could help him remember all the things that he needed to remember in order to carefully evaluate the propriety as a matter of public policy of agreeing to a 5-year community sentence for somebody who unquestionably had killed his wife. It wasn't denying it, but wasn't saying, wasn't acknowledging. So I think there are a variety of ways to do this. Is this ethical legal practice for me? Of course. I was going there talking about court rules. But in the process of talking about court rules, I was able to use myself strategically to help remind him about the impact of his very important role in our community. Anyway, so let's say that Sarah could have gotten a protection order because she could have gotten some representation because they would have recognized that sexual violence was in fact violence. Protection orders in my state last 1 year. We don't even have in our statute a basis for extension. When these guys whenever they walk out of this prison, Sarah will have no legal protections. The data suggests to me that cops respond better when women have protection orders. That it is almost, it is the basis on which they hang probable cause. She has a protection order, some court has decided that there was abuse, I will now arrest. I will now do other things. Let me also talk about, I'm one of those people who's not a mandatory arrest proponent, minority in this movement. I am not, and I don't want to talk about that, but I want to talk about the other part that I am very much in favor of, and that is really diligent, I'm trying to figure out the word, diligent police intervention that goes beyond arresting. The Massachusetts Code, for example, has a very long list of all the things that cops are supposed to do. And whether they do it all, it's a very educational tool. They are supposed to provide or assist in transportation to medical facilities. Provide or assist in transportation to safe shelter, either the relatives, one of your programs, anyplace else. They are to help her go back to once they protect her, go back to the house and take her personal belongings out of there if she wants it. They are to help her go to the house and evict the perpetrator of the protection order through the eviction. They are to do, there's 12 things on this list that are by statute required of police officers in Massachusetts. When I saw this, I thought, God, my teeth, because it was more than we ever asked, even by gracious request, let alone by statutory mandate of the cops in Pennsylvania. But it dawned on me that one of the things that we have done while pushing for arrests, so we have forgotten all of the other ways that police can be useful to better women. I'm one of those people who never wanted him arrested. I wanted him out of my house, I wanted my car returned, I wanted a safe escort out of the house, I wanted to get back to my house so I could get my escort to go to work the next day. I wanted all of those things. So when I looked at this Massachusetts Code recently, I thought, well, we have forgotten that
that many battered women actually wanted what I saw of assistance, and that's assistance in being able to manage my life when a terrorist would insist upon managing it. Now, you may say, well, cops can't do all that stuff. Cops can do all that stuff. Cops should do all that stuff. And the point being that we can, either by protocol and education, or by statute, compel them to do a variety of those things. You may look at that list from Massachusetts and decide, oh, it's too long, I'll never do it, they'll rebel. But we can get them to do 8. And if they did 8, it would be a great service to many battered women in managing their lives so they don't lose their jobs, so they can retain their vehicles, so they can have clothes to wear to their mother's birthday the next day, or whatever. So I'm hoping that we are politically astute and not just politically correct. I understand that being politically correct is very important. Me too. And that politically correct right now is a lot mandatory arrests, and a lot is no drop prosecution. I would just ask you, as somebody who's also I'm a proponent of victim discretion, if you will. And that means that I think that that informed battered women should be able to exercise control of their lives in the legal arena as in other arenas. And that means that I think that we might be doing things differently. You may disagree with me, I don't fight with you about it. But I would hope that we would engage in conversations about these issues so that we can shape and inform policy and statutes that in fact give women, battered women, the most options instead of one piece of relief. I mean, we've been working so hard at arrests recently that I think we've almost forgotten about protection orders. And in terms of our diligence, let me suggest to you, my time is up, Lynn. I'm sorry, we started late and I get some help. Okay, thanks. On this issue of victim discretion or victim input or victim leadership in making decisions about their lives, let me just say that we've done very, very little research on interventions, legal interventions. So we've heard the research about arrest. We haven't heard the research about protection orders and their efficacy, and that's because there's not much there. Adele Harold did some in Colorado, we've done some in Pennsylvania, there's been some done in Massachusetts and in Michigan, and that's all that I know of. Interesting pieces, interesting information. I'm not going to review that right now. But I think that we are sometimes forgetting the importance of protection orders. And those of us who are fans or advocates for protection orders, because we think women do choose protection orders. Nobody, a woman walks to that courthouse or to that attorney's office and says, I've heard about this option, I'd like to further investigate it, and then yea or nay, I want to proceed. If the woman is really, in many ways, making a determination that this option perhaps will affect the kinds of protection that she's interested in. What we discovered in our protection order research, which is not yet published, and I don't know necessarily the ethics of talking about data beforehand, but I'm not a researcher, and I'm not going to give you much information, so I'm not going to give you numbers. But what we discovered was that protection orders work for most battered women related to the injunction against violence and related to the eviction, related to the no contact order. That a substantial majority, someplace, and I don't know the number, or I will give it to you, someplace around 75%, someplace in that ballpark, actually those protection orders work related to eviction, related to no contact, related to an injunction against violence. At least they work if we're measuring work about whether a battered woman comes back in and asks for contempt. Now, there may be hundreds of women who don't come back in because they decide it's a flawed tool and they just don't want to, spend that time or risk that risk by going back to court. But at least it appears that most battered women get the kind of protection that we were hoping they would get with protection orders. As to those three elements, no contact, injunction against violence, and eviction. But what they don't get is the kind of help that makes continuing their lives in an empowered way. Oh, they don't get support. I mean, they get an order of it, but it doesn't get paid. And we have data, very, very powerful data that says the batterers pay support orders much less than non-batterers. Philadelphia data, I've got to share it with anybody who wants it. They don't get support. They get reasonable visitation. I don't know what reasonable visitation is in your state, but reasonable visitation in my state is every other weekend, one night a week, telephone access whenever you want it, one weekend, 1 week or 2 weeks in the summer, and just lots and lots and lots of contact. Judges in protection order courts are issuing the same kind of custody or visitation orders as they issue every place else, and they are not imposing the kind of protective conditions that will be essential for women to be able to manage their lives and to protect their children from what is the terror often and the fear and the anxiety related to visitation access. And so we haven't yet helped courts figure out that this is very, very different, and that we need to be issuing custody orders under the protection order statutes that look very different than those that are issued under the custody code. Let me also say that the other piece of the protection order doesn't work is that when battered women have sustained great losses, we estimate that every relocation probably costs $5,000 if a battered woman moves house. And that's probably an underestimate of all of the costs. So every relocation, $5,000. We have it in our statute. You can pay for relocation costs. We never do that. So I would say to you that battered women are pretty unhappy with protection orders about those pieces that don't work. And when the promise is that you're going to get this whole package of protection that includes economic sustenance, so that you can maintain yourself and you can maintain your autonomy. And when those economic pieces fall through, battered women are very discouraged, even though they're not being assaulted, even though they may have their own house. So what it says to us, who are the folks who are trying to upgrade this particular intervention, is that we've got to take this information to the judges, and it's going to be hard on our judges if they are really, it was the court administrator, the judges who really agree to this research, and now we're going to badmouth them on some levels. But they're the first and they're the best, and so we'll go to them and say, look at, folks, here's what battered women's experience is with this. And we understand that it takes more time to do these economic pieces in protection orders, but it's essential if she's going to be able to maintain the stability. Some of the work of Peter Jaffe in Canada suggests that one of the most important post-separation relief for battered women is stability. They don't have to move. They don't have to change jobs. If they can achieve a life that is stable, separate, they and their children do better. And our protection order practice right now is not giving them that economic autonomy that the statute promises. We're going to have to do something different, and you're going to have to do something different. Because I bet the same thing's happening in this state is happening in our state. I think that the other thing that is related to the law, but not necessarily legal, is safety planning. I think we need to do lethality assessment. I know that this lovely little lethality assessment thing that I put out is not contested by anybody. And Jackie Campbell has done some preliminary testing of danger of this assessment and prediction. But for those of you who agree with me by your experience that when you have a batterer who's strongly committed to ownership, for whom she is central to their lives, she is the glue that holds their lives together. For that batterer who is in grave despair about separation and the loss that means to him, and for that batterer who begins risk-taking like he's never, ever done before because he knows that he's losing her, we need to help battered women think about these things so that they can do good planning for their safety. And they can be better informed participants in the legal system, whether it's on the criminal side or on the civil side. Because I think that it's quite by accident, and in my case, by reflection, that I figured out how dangerous Lawrence was. Let me do this one real quick. I am one of those people who experienced the worst violence upon his understanding that I was leaving. That's when I lost my front teeth. That's when my 2 pair of glasses got broken in my face. The most likely endangering. That's when he began to really upgrading his car terrorism. For me, I was one of those people that that he had a maintenance level of violence until I said I was leaving. Then he went way up. I left. The incident that I didn't understand until I began reflecting years later about was that I moved to my parents' house in a very secure complex, you know, they actually had a guard out front. I moved to this house, and I was away for the weekend. My parents were away that weekend. My little brother, who was 10 years younger than me at the time, about 17, was in the house. Lawrence came to my parents' house and broke into that house. He emptied my entire room. Everything in my room, didn't touch the rest of the house. When we got home from the weekend and discovered this, my brother didn't even notice because the door to my room was closed. Okay? When we got home, I was astounded. And one court called up and said, you know, aren't you coming back? And I said, no, I hope you enjoy wearing my trench coat. Perhaps you, like the president, like to watch some television at the same time. And my stereo always was better than yours. You know, enjoy. I'm not coming back. And that's what I thought. I thought it was a tactic to get me back. But you see, he engaged in such incredible risk-taking from his perspective. This man who had never been arrested in his life put himself in a position. He was terrified of my father. My father was the most powerful person on his feet. And I shared that with him from time to time. But I mean, to come into my parents' home, for him, I understood was a great leap in risk-taking. It didn't dawn on me what might have happened had I been there. I wasn't there. The point is, had I been there, something very, very different might have happened. Because he was, from his perspective, risking his life to come and get me. And if he couldn't have captured me, my belief now is that he might have escalated his violence. Because he was throwing, from his perspective, throwing his life away by breaking into my parents' house. Now, I said I left Detroit and went to Washington because my parents had been so wonderful, and I didn't want to put them at risk. And I wanted, to protect them, and I wanted to protect my relationship with them because they had been so wonderful. So I said, I'm going to get out of here. I'm getting out of here as fast as I can. This man's going to do this. And I'm going to lose the support that's the difference between, me succeeding and achieving freedom and me being killed or me going back. So I left. But it wasn't until years later that I understood that, in fact, this may have ended in my death, but for the fact that I wasn't there. And I think that I think that battered women aren't given the opportunity to reflect on questions of ownership, centrality, desperation, and risk-taking because we don't talk about this kind of stuff. I want to also say that you can't tell her if he's going to do this. At this point, tell you I think that was what Lawrence was engaged in. I don't know. But she can better, if she has some hooks, some concepts on which to think about these things, can better decide if this is now the time to cut and run. This is the time to go and get a protection order. This is the time to pursue criminal prosecution. But if she hasn't had the opportunity to think through these things with you or separate from you once you've given her the tools to think about it, she's not going to be able to do the best safety planning. We've developed this 8-page tool for safety planning, so I'd be glad to share with you. It's really a tool to get women to begin to think about safety options, about how to respond in certain circumstances. But it's the beginning of, I think, of a long process of planning. Now, I also think that we need to look at some of the prediction research, and I'm going to just quickly tell you about some of this. We were trying to figure out if these guys, Sarah's assailants, we could persuade anybody by any data other than our own convictions. And we found this article by Chaikin last year. And they suggested, rather than using the typical predictors of the false indicators, I would call them, like guns, alcohol, prior drug, or assault convictions, burglary, auto theft, robbery, etc., those are not good predictors. Although we all think, or at least I certainly thought, that guns be a good predictor of post-incarceration recidivism. In fact, their data looked to find a cluster, and I want to give you that cluster, that where there's been a history of forcible rape or murder, or in the instance of Sarah, almost murder, but for her will and excellent medical treatment, where the most recent prosecution, in Sarah's case, for this assault, involves three separate transactions 3 different kinds of crimes, and it clearly did in this situation, where a knife was used, where the last victim was a woman, and where the assault was committed in an outside and public place. That cluster gives you fairly decent prediction ability related to violent recidivism post-incarceration. It fits for these 2 deaths. It absolutely fits. And it's different than many of the things. It certainly did. Most parole board look at good behavior in the institution, which is totally unrelated to anything, except that he's probably a very good counter. It's probably, the Alan Mathanes of the world who, first time they get a furlough, go and kill because they've been able to slide quite so nicely. So that's a cluster of prediction that I'd like to talk to you about. There's also some, and Kevin talked a little bit about it yesterday, but I want you to know that when you're advocating, that the National Crime Survey said that 50% of all victims of violent crimes are very fearful. And as a consequence, they're twice as likely to resist participation in prosecution. Makes sense, because we do very little to protect victims of crime during the prosecution process and thereafter. There's also, in terms of recidivism, interesting data from the National Crime Survey 1978 to 82. 32% of battered women were re-victimized within 6 months of the assault that brought the perpetrator into the system. 32% in 6 months. And the average number of times that they were re-victimized was 3 times within that 6 months. As to stranger crimes, only 13% instead of 32% were re-victimized within the 6 months, and only 1 assault instead of 3 assaults happened within those 6 months. I think this is good information to say these women are at elevated risk. So if we do lethality assessment, we do safety planning, we do some of this risk prediction, and we package it, frankly, then I think we can go to the reigning bail person, I don't know if you have a magistrate or whatever here, but whoever's doing the bail, and say, based on all of this, we think this guy's dangerous. And we need some very, very careful bail protections. And we propose the following list of bail protections. And we know you've never done this before, but you've not had such information about what high risk this perpetrator represents to the woman. We can do that at sentencing. We can do that in protection orders. In Sarah's case, where we probably couldn't have gotten relief because we had what was not seen as real abuse, we might be able to say, but since the purpose of protection orders is not retribution, is not to punish him for past crimes, but to prevent him from future crimes. When we say to you, we have actionable abuse, but we also have all of this data that suggests to us that this guy is likely to recidivate. Lots of data that suggests that he's likely to recidivate. She needs a protection order, even though it may be thin in terms of what's there in terms of abuse. I don't have time to talk about all the other laws that are going to change. But I've done, still, as much as I hate it, mostly criminal side. I haven't talked about all the custody work that I think we're going to do. We have to bring faults back into divorce so that we can have some recompense, if you will, reparations. So that women who are in economic destitution right now as a consequence of not getting those reparations get some. The other thing is, Sarah, for example, who knows? We don't know yet. I mean, I wrote to the NIH and said, have you done any medical research on breast cancer in battered women? So many battered women get pounded in their breasts. Is cancer trauma-based? And how long does it take? And do you have answers to any of those questions? And they said no. And I said, well, I'd like some answers. Who knows for Sarah? 20 years from now, 30 years from now? What kind of physical injuries or medical conditions she will have as a consequence of that violence? Should he not have to pay for that? So we have to look at a number of things. We need to look at our court statutes. We need to look at statute of limitations. I won't talk about all of that, but should not battered women be able to be made as whole as possible from those batters who have some bucks when their lives are forever? And at this point, we don't even know how much impeded, in Sarah's case, my case, impeded by the violence that was inflicted upon them. And we won't know of that injury or that condition probably for many years hence. Shouldn't we do something about that?
Yep, we should.
My answer. We have to do employment work. Maine, look at Maine statute. They have an unemployment compensation provision that says if a battered woman voluntarily quits her job because of domestic violence, even though and has made some reasonable efforts to retain her job, she should be entitled to unemployment compensation. What a support, a little bit of unemployment compensation, and as the feds continue to extend it. If battered women could know that they'd have to leave the job in order to leave him, but at least they could have that economic cushion, perhaps battered women would leave. Perhaps those women in Massachusetts who are not leaving, perhaps because they can't get housing, or maybe also because they don't have the economic wherewithal to purchase housing. And so if we change the unemployment law, there may be a difference. You're close to Denver. Denver School of Law just did a whole thing on employment benefits and employment protection for battered women. Call them if you're interested in employment law. Talk to them about the things that they can offer to you. I didn't talk about battered women in prison. Got something about that. Many battered women who are there for property offenses, for writing bad checks, to pay for credit, to pay for housing, pay for that shelter, that hotel that they went to, get away, and then he pulls all the money out and they get locked up. If the Framingham, Massachusetts data suggests that 60% of women are in there for property crimes that are like this kind of property crime, we're locking up women who are poor. We're locking up women who commit very marginal crimes in order to escape. I can speak for hours, so I'm going to stop. Let me do this. You did a spider web yesterday, so let me do an onion. None of you remember this spider web, but maybe you will after my onion. This is a very useful training tool, so it's not just because I can't stop talking, although that always is a deal. This is, I think, been very helpful to people, especially therapists, when I talk about this onion. Many layers, right? Skin on the outside is the consciousness of the community. It is the values, it is the vision, it is the way the world, and whatever culture you sit in, thinks about violence against women. That holds, from my perspective, the whole piece together. But there are layers underneath that contribute to a cessation or to a facilitation of violence against women. One of the layers underneath that certainly are all those institutions that Susan, that all three of you actually talked about yesterday. Whether it's religious institutions or the justice institutions or the therapeutic institutions, all of those institutions underneath there that don't know anything about this issue and therefore do poor service to battered women are the next piece, from my perspective, in terms of making change with those to end violence or to stop facilitating violence. Underneath this piece is the criminal justice system, which I think is much less significant in public consciousness and the whole context of community institutions. It is a much less significant piece, criminal and civil justice system. Underneath that, maybe, and I think it's less what I'm willing to argue with you all about this, is significant others. Those people in his family and friendship constellation that support or inhibit his continued violence. And then inside that is Battersburg. You can see that Battersburg is probably the least important of the tools to end violence against women. They're very much less important than all of these other things. And finally, in the middle, you got this kernel onion. You got this batter. My sense is if you bring all of these things to bear, all of these things are squeezing in, or the spider web is sticking in everywhere. Somebody is stopped by being stopped. Or you have an onion. All of these systems, if they are unified, they're giving the same message. If they are intolerant and clear, and if they are supportive of change and insistent upon change, and require accountability, I think if we pull this whole, so this talks about Susan's community-wide intervention. So it is everyone in his community, in our culture, that collectively squeezes, puts the pressure on this guy. And as long as we are consistent, we don't slice up this onion, this guy is going to be held within our collective system of accountability, and I would support so that he can exist. Now, there may be politically This little, somebody told me that I shouldn't do vegetable because I'm real creepy with vegetable development. But it makes sense to me, and it's been a good training tool for cops. It makes sense. You know, Lenore used to do respectful violence, and people thought that was sort of an icky thing. This, I think, helps those cops understand that it's their responsibility. It is the responsibility of the community. It's not her responsibility. It's not your responsibility. It's not their responsibility alone. And unless all of these systems are carefully tended to and called to account and supported in their insistence on the systems, that we're going to have continued terrorism against women. That's it. Thanks.
Thanks, Barb. I'd like to introduce to you the commentator for this portion of the workshop. Her name is Barry Burke, and she joined the law faculty at the University of Montana Law School in 1981. Barry has been an active part of academic program planning in addition to teaching law courses, which include Law and Society, Moot Court, Gender Bias and the Law, and she is the director of the Legal Writing Program. Barry has written and co-authored several law publications. She is a co-chair for the Montana State Bar Gender Fairness Task Force. She brings a combination of legal knowledge, feminism, and philosophical background to respond to this keynote by Barbara Hart on legal issues of domestic violence.
I am honored to be here this morning and one of the commentators. I don't know that anyone brings enough spirit to actually respond to Barbara Hart's talk this morning, which I found wonderful. I need to tell you probably that I am more of an academic, and I like to think of myself as an activist, than I am a specialist in this particular area. So the first thing I'd like to do is introduce a couple people in the room who, from a Montana legal perspective, are experts in the area, who can maybe both help me out this morning and serve as resources to those of you here who have specific questions now or later. Two of these people are former students of mine who surpass what I know in the area, which is always a fun thing to be able to say about former students. One is Judy Wang, and she is the assistant city attorney in Missoula who prosecutes abusers. Can you just raise your hand? The second is Judy Williams, who works with Billings Legal Services, and she represents female victims of domestic abuse. A person I don't know personally, but I have heard of, is Jim Johnson. He's here. He works with Legal Services in Butte and also does domestic violence work. Where is he? Maybe he stepped out. Second of all, in terms of resources for you, I think the legal system, and we've heard about it in the last couple days, is particularly poor with doing empirical work that supports statutes, decisions by judges, or less formal mechanisms in the legal system. One thing I'm pleased to say is that as a result of the movement of gender-biased task forces in different states, there is some empirical work, which I'm not sure is scientifically valid in all respects, but is worthwhile to the extent that I believe the people who were on the task forces went right to the people in the communities doing a lot of the work and tried to gather information from real people's perspectives, not just lawyers' perspectives. About 20 states have completed their gender bias task force reports. And in those reports, large parts of those reports are dedicated to domestic violence work, what's going on in the community, what the numbers look like, what some of the mechanisms that are effective are. The final reports of the task forces look something like this. This is the Maryland Task Force report. This is the Washington report. They're major compilations, and about a sixth of every one of these reports is dedicated to what's happening in the domestic violence area. So I commend these to you. They're free from the different states as one place to look at information about what's happening in certain states. not the formal statutory law necessarily or the case law, but what's actually happening according to workers in the area. The Montana Supreme Court about 2 years ago appointed a gender fairness task force. The task force worked for the first year on trying to put together a survey, and then for the last year has not done much because there is absolutely zero money in that statewide budget. The Supreme Court, when it appointed that task force, had no budget even to support meetings of the people throughout the state in the task force, much less to do any of the work. We know it's not a good time to ask the Montana legislature for money, so we're about to go back for a second time to members of the bar to ask for money. There is a representative on the task force who is a non-lawyer but a specialist in the area of domestic violence, Jackie Garcia from Billings, and so I know that as that work continues, you all will be asked for your advice and knowledge in the area. Please watch for that, and if you have ideas, let Max Hansen, who's a lawyer in Dillon, or me know, and we will do our best to get you involved in that task force work. You all may know more than I do about the statutory scheme in Montana that tells us something about domestic violence and domestic abuse. As was said by the introducer this morning, Montana has a specific domestic abuse statute, defines the crime, defines the possible victims, and does call for mandatory counseling of people convicted of domestic abuse. By the way, there should have been outside at the table a stapled together set of statutes, and some of the relevant statutes were part of that, so if you happen to pick that up, you'll have that packet with you. You should know that Judy Wang is working on some amendments to that statute and has asked some community people for their response. If you want to talk to Judy about possible amendments to any of these statutes that would make your work easier or more effective, please let her know because she's spearheading that effort. In terms of Montana statutes, we are a pro-arrest state. According from the statute, arrest is the preferred response in domestic abuse cases involving injury to the victim, use or threatened use of a weapon, violation of a restraining order, or other imminent danger to the victim. I'm not going to go through all the statutes that have something to do with domestic abuse because they're part of that handout, and if you come to the law school, any of us can help you find those statutes if you in fact don't have them. We do have a statute that provides for temporary orders or temporary injunctions in a situation where a person seeks that relief, even when that person is not petitioning for a dissolution of marriage, when the person alleges physical abuse, harm, or bodily injury. Although it's limited to family or household members of the batterer, and Judy Wang is also doing some work on whether we need to expand the definition of possible victim. Also, in our family law statutes, when a court determines custody and what is in the best interest of the child, the court considers a list of relevant factors, one of which is physical abuse or threat of physical abuse by one parent against the other parent or child. Similarly, when a court decides on visitation, if the non-custodial parent has been convicted of, for example, domestic abuse, the court takes that into account. At least the court is directed to take that into account under this statute. And the same with modifying orders. But now what I want to do is tell you just about 4 cases that have been decided very recently in Montana, and you can determine whether, according to the Montana Supreme Court, we're living up to our statutory scheme. There was a case called In Re Hoodenpyle, which was a 1990 decision of the Montana Supreme Court. And in that case, the parties were granted joint custody of the 2 children at the time of divorce, with the husband as primary custodian. 4 months later, the ex-wife filed a motion to modify custody, and the ex-husband resisted that. The district court, the lower court, denied the wife's motion to modify the joint custody arrangement, and the final decision of the Montana Supreme Court was to affirm that decision. What's interesting in the decision is that the majority opinion, the Montana Supreme Court takes up the issue of whether the husband is a good enough housekeeper to provide a good home for his children. And if you read only the majority opinion, one finds it hard to side with
the mother
should modify custody. But the dissent, and by the way, I think that opinions of higher courts are interesting because one very rarely gets the full set of facts and a flavor of what truly happened as we got when Barbara Hart told us the story of Sarah. I'm sure if there were a decision of the highest court in Pennsylvania, one wouldn't know the same facts as one would know if one talked to the people who worked with Sarah all the way through. The dissent points out in Ray Hoodenpyle that the mother actually had other allegations about why the father was not necessarily in the best position to be a primary caretaker, which the majority absolutely neglected to mention. For example, and by the way, the dissent was written by the sole female justice on the court at that time. The dissent pointed out, quote, "The majority disregards evidence of respondents' abuse of various chemical substances," goes on to mention some other problems, and then says, "These difficulties extended to respondents' verbal abuse of the children, a pattern carried out in his treatment of his children during the home investigation. Respondent further has a history of domestic abuse and was once arrested on such a charge." Now, according to the majority, that's irrelevant, and it's never mentioned. So the father kept primary custody of the children. I can't dispute the ultimate decisions in this case because the factual record in the opinion is so short. What I can say is the majority is somehow not even finding the information relevant enough to address and then refute. In a 1988 case, In re Hutchins was similarly in action for dissolution. District court awarded custody of the minor children to the mother and ordered the father to pay child support. The father appealed. What was interesting in that case is that the mother had requested sole custody, which she got sole physical custody, presenting testimony that the father had physically abused her during the marriage. The court did award custody to the mother with visitation to the father on alternate weekends and holidays and for 6 weeks each summer. Now, if you read the opinion of the court, you don't have any idea that the mother has presented evidence of domestic violence. And when you read the dissent says, "If we accept in full the findings of fact made by the district court, particularly including those related to battery, the conclusions on order derived therefrom do not make sense. Granting the father full visitation custody of the boy for 6 weeks during the summer and on every alternate major holiday belies the findings that the child would suffer battery himself or have an improper role model." So if the court awards full custody to the mother because the father is a batterer, then one would expect the court not to award 6 weeks of unsupervised visitation to the father, but it does. Then, that's one problem. The second problem is then the dissent turns around and says, so we can't really believe what the record tells us about abuse. And the dissent goes on to say, in fact, I choose not to, rather than disagreeing with the majority that the father should have unsupervised visitation for 6 weeks, the dissent goes farther than the majority and says, I would have awarded joint custody to the parents and disregarded this evidence about abuse. And I would have let the little boy stay with the father on during the school year, because the father had a job in which he worked during the summer, and I would have awarded custody to the mother during the summer because she was a teacher and didn't work during the summer. So the dissent goes even further then in not attending to what the facts on the record about abuse. Maybe or maybe not more disturbing are two similarly relevant cases, a 1990 case and a 1992 case. Both cases involved termination of parental rights for the mother, and in both cases, the facts were shocking and horrifying. Neither parent was a model parent according to middle-class standards of parenting. And I don't know what I would have done as a judge in terms of awarding custody, visitation, terminating rights. And when you read the facts of the cases, I think one can only feel some sense of heartrending sympathy for the children and what could have been done for the children. But from a position of interest about domestic violence, in each case, there were quotes that I just want to tell you that I think tip off the perspective of the court. And to me, perspective is critical when we look at the onion, and mostly the outside layer of the onion, which I think permeates the rest. In one case, one of the rationales the court used for terminating the mother's parental rights, and I quote, Only 3 weeks prior to the termination hearing, mother placed herself in an abusive situation by living with another man who had a history of domestic violence and alcohol abuse. Mother indicated that she would like to continue a friendship with this person, unquote. And like I said, I have nothing to say about the termination because the facts really were horrifying in the cases. They involved sexual abuse and, in one case, death of a child, etc. But the idea that what bolsters the termination of the rights is that the mother places herself in a domestic abusive situation is hard. And in the second case, the court says, quote, the mother continually exposed her children to a harmful living environment fraught with the potential for sexual abuse. She apparently has a propensity to associate herself with physically and sexually abusive men and has shown no prospect that she will change this course of conduct. Once again, putting the responsibility for battering right on the victim. Now, there's good news in terms of what the court's been doing recently. In 2 cases, a man convicted of, in 2 cases, 2 men were convicted of either felony assault or other charges that stemmed from battering of a living partner, a significant other. In both cases, the prosecutor charged with a crime that imposed a more significant penalty than the domestic abuse statute imposed. In both cases, the convicted batterer argued that, although he did something wrong, he only did domestic abuse and should have been charged with domestic abuse, and then only gotten the penalty that went with that statute and not with the other 2. In both cases, the Montana Supreme Court, for legal reasons, for technical legal reasons, said no, it is fine for the prosecutor to charge both domestic abuse and a crime that has a higher penalty, and if the prosecutor can make out the essential elements of that higher crime, that's fine. Lastly, in terms of the case law, I need to tell you that currently before the Montana Supreme Court is a very interesting case raising the issue whether district courts can routinely grant mutual preliminary injunctions. Meaning when a woman comes in asking for some kind of protective order and the man does not ask for a mutual protective order, can the court on its own decide that it wants to grant a mutual protective order? Now, probably you know this better than I, but some of you may not know what would be so wrong about doing that. There are at least 3 wrong things if a court awards a mutual protective order in a case where the wife has done absolutely nothing to scare, terrify, or injure the husband, and the husband has done committed acts that create reason for worry about physical injury or physical injury itself. The first is that a mutual injunction tells all of us that both parties have committed acts of domestic violence, otherwise why order that? And in which case, later violations of that protective order make a court reluctant to hold one of the parties rather than both of the parties in contempt. Second of all, and we're back to the outside of the onion skin, the message we all get with a mutual protective order, but especially the abuser, is that the parties are active and equal participants in the violence. That's absolutely untrue. And finally, if one of the reasons for protective orders, as Barbara Hart said this morning, is to help the police or help the victim get the police's protection, a mutual protection order merely confuses the police about what to do. And in some cases, if a batterer starts to abuse a woman and a woman tries to defend herself and then the police show up, the police from the mutual protective order get the idea that both parties have been violent, are being violent, and the police have to either arrest both parties or arrest neither party. That case is currently in front of the Montana Supreme Court. It's been briefed. Billings Legal Services represented the woman in that case. Deborah Onspaw wrote the brief, but Judy Williams knows a lot about the case too, so if you have more questions, I think she would be happy to answer those sometime today. Finally, as an academic, I want to raise one issue with all of you about the importance of both going to battered women or victims and empowering them and looking at all of this with a new perspective. As I said at the beginning, I'm not a specialist in the area of domestic violence. Although it's hard to do work on gender bias in society or in the law and not know something about domestic violence. In the time that I've been aware of the problem, it seems to me we've gone through at least 2 stages and we're about to enter a 3rd stage. The first stage, which for all of us I think was the beginning of our awareness about this, is that the problem was invisible and didn't exist. And people fought like crazy to have the problem identified and named and responded to in some way, shape, or form. And the woman who introduced Barbara Hart this morning talked a little bit about the history of that process in Montana. The second stage of addressing domestic violence seems to me that we've gotten as far as for some people to recognize that the problem is common, although most people, especially people like judges, to think that the problem is really rare, and in large part rests with the psychology of women. I think that for all the good the idea of the cycle of violence it did some bad in terms of putting the problem on women. Women were helpless, and here's how women got to be helpless. They went through this cycle. I think we're entering a 3rd stage now where not only can we find most people, more people, acknowledging that the problem with violence against women is common, but as Barbara Hart mentioned all the way through her talk this morning, the problem is the batterer's quest for control, not the psychology of women. Not why do we stay with battering spouses, but why do some men have such an incredible urge for control, sexual control, physical control. And one of the most interesting articles I think written recently was written by a woman whose name is Martha Mahoney. She herself was a battered woman, although she hates that label. She wrote an article called Legal Images of Battered Women, Redefining the Issue of Separation. It's a law review article that she wrote a short time after she graduated from Stanford Law School. There's a number of reasons that article is particularly moving to me, not only because she was a battered woman, and not only because a lot of her article comes from conversations she had with law students and other students and women who at the time weren't students, but all of whom were battered women. So the voice of that article is very much not somebody who's merely a scholar. But because she insists that we reset our perspective on the legal system and battered women and stop asking the question, why didn't she leave? And start looking at what Barbara Hart talked about this morning, which is the idea that at the time women decide to separate, batterers' violence increases so seriously that if it hasn't until that point, it does at that point become something that's life-threatening whether we recognize it or not. And that we continue, therefore, to listen to women's perspectives, especially victims' perspectives, workers' perspectives, on how to conceive of the problem of domestic violence and what solutions we might propose. I think that the onion metaphor is a wonderful metaphor because what happens in the legal system is it is just permeated by the perspective of everybody outside the legal system, and it reflects that and very often is behind rather than in front of what might be done. Thank you.